Hi, John. Thanks for sitting down with us today. So, as you know, HUD just released guidance on ex-offenders and how owners can screen ex-offenders in resident screening. Some of the issues I've heard from members are whether they'll be able to continue to adequately protect residents, employees, and properties, and also worries about increased litigation costs due to fair housing claims, and also potential liability exposure for crimes committed on the property by an ex-offender. So, in your opinion, can you tell us what the significance is of this new HUD guidance?
Well, actually, the guidance is fairly predictable. Following the Supreme Court ruling last year, the Supreme Court kind of raised the bar for what the burden of proof was going to be in disparate impact cases. And to take it back a couple of steps further, before the Supreme Court ruled, HUD had issued regulations on disparate impact. The Secretary had written housing providers on the importance of returning convicted persons to normal society and housing of their own. And so this is it's the kind of the latest reflection of a long-standing HUD policy.
Can you elaborate? How does this relate to the Supreme Court's decision in the Inclusive Communities case?
So the Supreme Court case, what it did was it upset the HUD regulations that it had issued on disparate impact, and as I said, kind of raised the standard of proof. What the Supreme Court said is that you can make an initial showing that you have a disparate impact on certain groups, and then that shifts the burden over. But as Justice Kennedy was writing in that opinion, the burden of proof was a lot higher, according to the Supreme Court, than it was under the pre-existing HUD regulation.
So in the guidance, HUD goes on to say a housing provider must be able to prove through reliable evidence that its policy or practice of making housing decisions based on criminal history actually assists in protecting resident safety and property. It can't just be bald assertions. What are your thoughts on that?
I think what a lot of the commentary has ignored, the commentary that has come since this guidance was issued, is that under the disparate impact analysis, after a plaintiff or HUD itself makes this prima facie showing that some group might have a disparate impact upon it, the burden shifts to the other side, to the defendant, and what they have to do is come up with a business necessity, or why would you do this? And the fact of the matter is that apartment communities have been sued for crimes committed by third parties on their properties for, I'd say at least 60 years. So this is a well-recognized business necessity, and there's case law on third-party liability in all 50 states. You have expert witnesses in those cases who will say the failure to screen is negligent on the part of the owners or managers. So the business necessity is a matter of established case law throughout the country, and that would then shove the burden of proof back to HUD, and really they don't have anywhere to go with that.
So on the topic of arrest records, how should owners handle these arrest records in their screening policies?
The guidance says clearly that they would view a policy that bars prospective tenants on prior arrests alone as a violation of the Fair Housing Act. They're entitled to that opinion. However, from a screening standpoint, don't you want all the information you can get? So whereas some of the commentators, since this guidance came out, have said ignore all arrest data, that's wrong. The guidance, and I think this is consistent with HUD policy, is that they want decisions made on an individual basis, and so to do that, to comply with what they're trying to accomplish, we need as much information as possible, and that would include arrest. What I would say is you shouldn't advertise a policy that says any criminal activity, including arrest, we'll screen you for. And we're not going to approve you for housing. Just make that one factor to take into consideration.
Well, what about drug convictions?
Okay. Drug cases. First, you have to draw the distinction between drug possession cases and selling drugs or manufacturing drug cases. Under the Fair Housing Act, if you manufacture or sell drugs, you can exclude those prospective tenants with any convictions in that area. Or if you have reason to believe, even without the convictions, or you have reason to believe that that activity is going to be going on associated with that individual, you can screen them. Now, the sad irony is that 30% of the cases, and at least in the federal system, involve those types of cases. So whatever this guidance is supposed to accomplish, they've already limited themselves, because the Fair Housing Act prohibits them from being more aggressive, to only 70% of the convicted population. The other thing is that the only people who do go away, that is, serve some term of incarceration in most courts, are going to be the people who sold or manufactured drugs. People who get arrested with small amounts of possession are typically offered some sort of diversion program, or it's some misdemeanor, and more often than not, people are not incarcerated or given prison sentences as a result of misdemeanor convictions.
So there's no such bright line exceptions for other offenses?
So apart from those drug convictions, there is no particular bright line. I mean, one could argue that a drug sale conviction is a nonviolent crime, but in that 70% figure of the non-drug convictions, there are people who are violent offenders, and they are eventually going to get released from their term of imprisonment. Yet the administration, or more particularly this agency, what HUD's guidance is saying is that you should try and accommodate them, and I guess give them the benefit of the doubt.
How would you advise NAA members going forward?
Okay, my advice would be, well, a couple of different facets to the advice. First part would be, take a look at your websites, and if you have a statement in there that on the website that says, "We don't rent to anyone with any criminal record," take that down. That's like putting a target on your back. You might as well just embrace the idea that there is going to be some sort of individual assessment. And what I mean by that is that as you take in the data, felony should be weighted more seriously than a misdemeanor. A recent offense, say within the last 5 years, should be weighted more seriously than something that happened more than 10 years ago. And just build that into to your criteria. There is a white paper that's coming out, but that was written by Mike Skojak, a lawyer who's well-recognized authority in fair housing, that was commissioned by NAA and the National Multi-Housing Council. I would urge you to take a look at that when it becomes available. I would also caution you that despite all the criticism and fanfare that has arisen after this guidance, remember that this is an initiative of the current administration, which has decided that this is going to be one of its priorities in the last days, and who knows whether this is also going to be a priority under the next administration, whomever that may be.
John, beyond what we talked about here, what do you recommend to members if they want more information on this topic?
Well, I'd certainly advise them to read the white paper when it becomes available, the one that I mentioned before. Read the article in the May issue of Units magazine, and I'm sure that NAA is going to continue to report should the Lawyers Committee or should HUD bring any sort of action. We'll be reporting to the membership to try and keep them informed as best we can.
Great. Thanks, John.
You're welcome.
Yeah, thank you, John. I'm sure this is all going to go a long way in easing some of our members' concerns.
I hope so, Frank.